Hi, my name is Brian King with King Law Offices, and today I want to talk to you a little bit about do-it-yourself divorce. I've been an attorney for 20 years and a family law specialist for 10 years in North and South Carolina. We have offices in 15 different locations, and I've practiced in about 20 different counties in North Carolina in cases just like this. And one trend that I've noticed over time is that more and more people are doing their own divorce. Now, this is difficult, and it's not necessarily advisable, but I understand that 80% of all litigants do not have the funds or resources or just want to have an attorney involved. So I want to talk to you a little bit about doing a divorce yourself and what that might mean. First off, you're going to need to file a complaint for divorce. And that means you have to qualify for divorce. In North Carolina, that means that you've been married, of course, and been separated for more than 1 year. Once you have been separated for 1 year with no intent to live together again, then you can file for divorce. You need to file a complaint. Now I'm going to put that below. I'm going to give you a sample complaint that you could use to file a document which will allow for you to start the divorce process. Now, along with that complaint, you'll attach a summons. Again, I'll have a reference for that because that summons is available by the state of North Carolina, the same document I would file. And in North Carolina recently, although the law's been there for some time, I've noticed judges requiring an affidavit of service showing that the defendant or the person that you're going to be suing for divorce is not a member of the armed forces. If that's the case, that's a whole nother issue, and maybe we'll talk about that in a later video. Once you have your complaint, your summons, and your affidavit of service, have those ready and take them to the courthouse. Now, you'll have to file that paperwork with the clerk of court. Now, they're not there to give you legal advice. When you ask them questions, they're not allowed to give you legal advice. So it's important for you to have that documentation and paperwork when you walk there and you're ready to go. Once you do that and you file that paperwork, you have to serve the paperwork. Sometimes service is the most difficult part. There are several ways you can serve that paperwork. Preferred is going to be through sheriff's service. If the defendant lives in that county, they may at that time be able to take paperwork and give it to the sheriff's department to serve the defendant. So you need to have a good solid address for the person who you are serving before you go into this process, and let them know who that person is. You can also serve by certified mail, and what that means is serve it by certified mail with the U.S. Post Office, but it also means that you have to have it return receipt requested. So that person needs to sign their name onto that paperwork in order to show that they have in fact been served. It's important for that to happen so the judge knows that the other person actually knows that the divorce has happened. There's some other ways to serve, and obviously a lot more rules to that, but those are the most popular and most clear ways in order to get that service done. If it's a sheriff, the sheriff would then take that paperwork back and show that it has been served. If you're doing it certified mail, that's up to you, and it shows that you're going to have to do an affidavit of service. And you'll take that green card once it's returned to you, showing that their signature, and you have an affidavit, a document showing that you served it and that they know now that the divorce is going forward. And they have to legally know this. Just because you've called them or they know it in some other way, you have to be able to show to the court on paper by their signature that they have been served, or of course the sheriff's signature and affidavit. That document, I'll also try to put that down below as well. Once you get that done, they have 30 days to respond. If they don't respond after 30 days, the clerk can do their own judgment. That's if there is no other issues, or you'll be appearing in front of a judge. Now let me stop here and say again, there are a lot of issues that happen when that divorce judgment goes through. Number one, you are not going to be allowed to have a property settlement, an equitable distribution of that property once that divorce is entered. It is vital that you get that done before you go through this divorce process. Other financial matters like alimony can also be lost once that divorce is entered. You cannot get the divorce and then start talking about those marital claims. Those need to be done before divorce. It obviously gets more messy when there's children involved, And when there's children involved, this does not do a custody order. It doesn't make an arrangement. It doesn't deal with child support. Those are all separate issues. And I encourage you to talk to a lawyer about those things. But let's say that you've got these documents filed, it's been served, it's been 30 days, and now you're going to court. Now, oftentimes you'll have to send to the other side a notice of hearing showing them when this court date is going to happen. The clerk will let you know when that goes on, and it will be your big day in court. You'll go in front of the judge when the judge calls your name up. When that happens, the judge is going to ask you to present your case. The judges cannot give you legal advice. They're not going to help you out. That complaint is going to give you the information you need. You're going to need to read off those things in the complaint after being sworn in, under oath, or affirm that those things are true. The judge is going to ask you if you do want a divorce. They're going to make sure that the other party has been served, but they're not going to help you with those questions. It's going to be up to you to present all that information from that complaint. If you've done that right, you'll have a judgment prepared. You need to have a copy yourself. You need to have one for the judge. You need to have one ready for just in case your spouse, soon-to-be former spouse, shows up. That's a lot of work, and I would not advise you to do it yourself any more than I'd advise you to go and pull your own tooth or not use a dentist or a doctor when you're having surgery. It's that important. And I think a lot of people avoid having an attorney because they just don't know how much it's going to cost. They hear thousands and thousands of dollars. That's simply not true. At King Law Offices, we try to keep that cost as low as possible, and for a divorce, that could be $750 or below in order to get this process done. You're already going to be paying $200 to $300 at least in expenses and costs and fees that are required by the state in order to go forward with that. So what I would encourage you to do is pick up the phone and give us a call. We'd be more than happy to talk over this with you, just to discuss it, and no more than the consultation fee, that we could take a look and make sure that you're on the right path. I look forward to seeing you in our offices, or if you're in court, feel free to say hello to me or to any of our attorneys, and good luck with this process. That's a do-it-yourself divorce in North Carolina.